Welcome to Landlord Law TV. My name is Ben Reeve-Lewis and this is the noted lawyer extraordinaire Tessa Shepperson. This week we're going to be talking about letting agents' fees. It's a vexed subject that's been in the news quite a bit over the last couple of years, and as usual we've got to kickstart it with a query. Someone wants explaining. John from Winchester has sent in a query saying, my letting agents have just been taken over by a new company and have introduced all sorts of fees which the old agent never charged. Do I have to pay them? Does he?
Well, probably no. No, he doesn't, because the new letting agents will sort of be like standing in the shoes of the old letting agents. They just take over the contract that the old agent started, and they can't keep introducing new fees just like that unless the client, the landlord, has agreed to them. So no, they can't. Particularly under agency law, there's very strict rules as to what agents can and can't charge, and they can only really charge what they've actually been authorised. There's sort of special duty of care that they have. So no, they can't charge that.
Do they have to abide by the terms of the original contract that he had?
Yeah, unless it's been altered, yes they do.
Yeah.
So John needs to look at what the original contract says, and if they want to charge something else, he's going to say, well, I haven't agreed to that, you're not entitled to charge it.
So technically speaking, they could have half of their landlord clients on the old contract and half on the new as they sign up. Yeah.
Okay. So I mean, if they get John to sign a new contract, then that'll be fine. But otherwise not. I mean, there have also been new regulations introduced for letting agents' fees recently. For the new agreements, they need to put all their charges up in the office and on their website. They need to be very detailed. So, for example, they need to know if they're charging per tenant or per property, and all the fees need to be inclusive of VAT, because often agents are a bit naughty and they put their prices up ex VAT, because that's not what the landlord and the tenant are actually going to pay, and a lot of their customers are not going to be VAT registered. So, you know, the inclusive VAT is what they actually pay. So it's really important that they do that. If a landlord or for example, John, if he finds that the agent is charging things which he thinks that he doesn't have to pay, first of all, he needs to go to the agents and talk to them and say, look, excuse me, you know, I don't think you're entitled to pay that, and try and sort it out with them direct. If he's not able to sort it out, then all letting agents and property managers now need to be a member of a property redress scheme. There are three schemes. There's the Property Ombudsman, there's the Property Ombudsman Services,
very close.
And there's the Property Redress Scheme, which is the new kid on the block. That's the new scheme, and they can report them, and the Ombudsman can try and sort it out or adjudicate. Ombudsmen have actually got the power to charge up to £25,000 now, and to order people to make apologies and things. As I said, all agents now need to be registered with one of these. If they're not, then local authorities can go in and fine them. And if they don't register with an ombudsman, they're not strictly speaking supposed to be trading.
Yeah, it's been a mixed response from the local authority world. Newham Council, the famous Newham, who are very keen on these sort of stuff, have put together a special team, and they've been targeting these people and going in and doing these things called penalty charge notices, PCNs, and their trading standards team will find out who isn't a member of the scheme and just go straight in on them. But in other boroughs, it's been a bit of a mixed bag. Some of them just haven't had the resources to get round to it.
There was a report which was mentioned in one of the property industry posts, which said that in some trading standards offices, that they're very keen on doing things like weights and measures in markets and cars and things, and letting agents at the bottom of the list. So hopefully that's going to change, and they're going to change their priorities a bit, because it is important that these things are dealt with properly.
I know in the past a lot of letting agents have been very reluctant to discuss their fees. They've said because it hampers their ability to do deals with individual landlords. But do you think it would do?
Well, they've now got to. I mean, it's the law. They've now got to have their fees up front. I mean, it may be that the landlord will be able to do a deal with them, but they need to have their basic fees there so people know where they stand, and also so landlords can compare one agent against the other.
Yeah.
So I'm afraid agents are going to have to do that now.
It's going to be interesting, isn't it? Because a lot of it resides in the small print. There's a lot of news recently about Foxtons and the fees that they charge for employing contractors, and it's buried in the small print that they can charge a fee and use their own contractor, then put VAT on the fee, and once it goes over a certain figure they charge even more. And
they take commission. They take commission for, and yes, I mean there is a case that's being brought by Solicitors Lead A on this, which we're going to feature in one of our features. So so they're not supposed to do that either. Things aren't supposed to be anything to do with any financial payment. It shouldn't be hidden in the small print. It should be drawn to the landlord's attention before they enter into the contract. Otherwise, the agent risks it not being enforceable.
I think there's a lot of pressure on letting agents now. I mean, in Scotland it's illegal to charge fees to tenants. Wales are completely changing the law on it, leaving England quite isolated. And I always thought it was a bit of a strange thing that where estate agents have to be registered and regulated, and letting agent doesn't at all. Well,
they do say that the letting agent industry is sort of like the Wild West, don't they?
And there's certainly some cowboys in it.
There's certainly some cowboys, yeah. So yes, but I think regulation is coming. It's not going to stay as it is. It looks like they are going to bring more regulation, and we've now got as I said, the ombudsman, the mandatory ombudsman. They've got to disclose their fees. Probably other things are going to come, because there have been such awful stories in the past of letting agents who've gone off with landlords' money, thousands of pounds. Some landlords have lost sometimes. So it's only right that it should be registered.
Well, I've seen that in 25 years as an enforcement officer in the London Borough of Lewisham. I can remember years ago, back in the 90s, there were maybe 30 or 40 letting agents in the borough. Since the explosion in the private rented sector, I remember a few months ago sitting down with an Excel spreadsheet and trying to map down the ones that we had, and I got to about 150 and gave up. So there's a lot of people just coming on with no experience whatsoever, just think, get in, get the commission, and there you go.
Yes, well, it's a very sort of detailed and complex job, and there's a lot of law that you need to know. If you're a landlord looking out for a letting agent, one thing you need to check is that they have got client money protection insurance in place.
Which is voluntary though, isn't it?
It is voluntary, but that's something that they are supposed to disclose. Along with their fees, they need to disclose whether they've got client money protection and what property redress scheme they're registered with. So you need to make sure that they do have that insurance, because that is really important. Otherwise, if they go under, your fees are gone.
Yeah, I'd say it's absolutely crucial. There have been a lot of stories in the last few years where letting agents have gone out of business, and they've taken all of the held deposit money, which has affected the landlords and the tenants.
It certainly has, yeah. Well, I mean, it's affected the landlords more than the tenants, really, because the tenants are still entitled to that money, and they can claim it from the landlord. Even though it's the agents that lost it, the landlord is responsible, because the landlord is responsible for everything the agent does, because the agent is sort of like his agent. It's like an extra arm of the landlord doing something on behalf of the landlord. So the landlord is responsible for that. So if the agent goes down with all the money, then not only have the landlords lost their rent, but they're also legally liable to pay the deposit to the tenants.
So they lose twice.
So, be very careful, landlords, when you choose your agents.
Yeah, well, I mean, this is the thing. Choosing an agent, you can go to the big high street chains. They'll probably charge more. They tend generally to know what they're doing. But there's some also brilliant small local independents. We know the woman from Apple down in Taunton, a small agency runs
Daisy Letts
in East Dulwich, where I live.
Yes, there's some great
fantastic people. Yeah.
Just be careful.
Yeah.
Okay.
So there you go. Pick your letting agent with care. The fees need to be upfront and transparent now. You could lose out big time, as Tessa said. And
they can't introduce new fees halfway through your contract without your consent.
There you go. 10 minutes of talking, John, and we got round to the answer in the end. We'll see you next time on Landlord Law TV.
Chester Shepperson, and I'm here today with David Cox of ARLA and at the ARLA and NAEA conference in Norwich. David, can you tell us a little bit first about yourself?
Absolutely, yes. Well, I'm currently the Managing Director of ARLA. I took up post last June 2014 when ARLA's previous Managing Director, Ian Potter, retired. Before that, I was a trained barrister, worked at the Old Bailey before moving into Parliament. Got kind of the political bug, wanted to go into lobbying, so I went to work for the National Landlord Association for 5 years.
Oh, right.
Was over in Brussels actually for 12 months doing some European lobbying, and then came to ARLA.
So can you tell us a little bit about ARLA and your role?
ARLA, the Association of Residential Letting Agents, we were formed in 1981 as the professional and regulatory body for the lettings industry. And I would say today that we are probably the closest there is to a regulatory body in the industry.
Yeah.
If you think about it, the law's kind of here. The requirements that we have on our members put them way above what the law requires. We require all of our members to hold a professional qualification that is actually regulated by the Office of Qualifications in exactly the same way as A-levels, GCSEs are. We require them to do continued professional development every year, to have client money protection, so that in the event that the agent goes bust or maybe somebody misappropriates the funds, landlords and tenants won't be out of pocket. We will give them the money back through ARLA. We require them to provide us with an independently audited copy of their client accounts report every year.
So it's proper regulation?
It's the closest we can get, and it's what we are calling on government to actually do, and to put a system of regulation akin to our membership requirements on the statute books, so that there is a level playing field. And something that I get from members on a very regular basis is, we're being held up here, but law's here, and we know there are many that are operating down here.
Absolutely, yes.
So our campaigning for government at the moment is we want a properly regulated industry, a much more appropriate regulation than some of the laws that we're seeing at the moment, combined with much better enforcement.
Yes. Well,
now, certainly this government and the new government since May this year, they're taking on board the enforcement aspects.
Good.
They're not doing the regulation aspect so much. And whilst we have a Conservative government that doesn't really believe in additional regulation and considers it as unnecessary additional costs to business, we will continue fighting the regulation argument, but we are going to be getting the enforcement aspects.
Talking about the additional regulation, there are, of course, a vast number of new regulations that came into force on the 1st of October.
There are indeed.
Can you talk a little bit specifically about how these will affect letting agents and how they're going to have to amend their systems to take account of them?
Absolutely. There has been a raft. 4 new pieces of legislation came in on the 1st of October. Generally positive, but much of it not well designed.
Yes.
So if we start looking at the smoke and carbon monoxide regulation, we didn't object to the regulations at all. They require that every rented property must have a smoke alarm on every floor. And by floor, I do mean if you've got a flat above a shop, for example, and the entrance to the flat is at the shop level, at street level, that is classed as a floor. And you require a carbon monoxide alarm in every room where solid fuel is burnt, so a wood burner, an open fire, coal. We actually thought it should have gone further. It should have included gas.
Yes, that was odd. Gas and oil isn't included. That's very strange.
Exactly, and we actually made that argument to government, and government's response was, well, we require you to have an annual gas safety certificate, therefore effectively we're gold plating the regulations. Now, I would argue the gas safety certificate, necessary, no objections to it whatsoever, but it's akin to an MOT.
Yeah.
Now, when the car fails, or the brakes fail between MOTs, you go and get the brakes fixed. If you've got a carbon monoxide leak between gas safety checks, potentially the first time you're going to know about that is when somebody dies.
Yes, we don't want that.
Exactly, which is why we would have argued that it should have included gas. Best practice is to have a carbon monoxide alarm installed near the gas flues and the gas boilers. It's in the private rented sector code as best practice as well. But actually, if you look at oil and LPG, there's absolutely no requirements to check oil and LPG, and particularly LPG. If something goes wrong with that, it goes bang.
Talking about the checks, I mean, the regulations say it needs to be checked on the first day of the tenancy. I mean, that's going to impact
chaos.
quite a bit on agents.
Absolutely, and it's something that in no other law does it need to be on the first day of the tenancy. We lobbied very hard, and a lot of lords spoke out against this during the debate on the regulation, that a little bit of leeway, because particularly for agents that are managing large portfolios, a lot of check-ins are weekends, Fridays, Saturdays. When you've got small numbers of staff checking in large numbers of tenants, it's going to be very, very difficult. And are the inventory providers going to be doing it? Some agents will ask the inventory providers to do it, some won't. But if the inventory is done maybe a couple of days before, they won't be able to do it because it has to be on the day of the tenancy.
Yes.
And you have 24 hours from midnight on the day that it starts to 11:59 that evening. And it will be very, very difficult. We've asked for a bit of leeway, and we have to remember that they need to be tested on the start of all new tenancies, but you already need smoke alarms, carbon monoxide alarms.
For the existing ones.
And when the regulations passed, there were 13 working days left to potentially install several million smoke alarms. It was just not practical. And many lords spoke out against it, many of the MPs spoke out against it as well, but unfortunately the government did push it through.
Okay.
The other side, of course, is we have the changes to the Section 21.
We do.
And quite a raft of changes to Section 21. Would you like me to go through them in slightly more detail?
Perhaps skate over the top of them and just summarise them. It's the requirements when you have a new tenancy, there's new requirements.
Well, under the new Section 21 requirements from the 1st of October, you need to serve EPC gas safety certificate as normal, as you have done. You can't serve a Section 21 notice in the first 4 months of a tenancy.
That's right.
They only last for 6 months, so you can't just serve and leave it and then use it potentially 2 years down the line, as you have done previously. They'll only have a 6-month lifespan. You have to also now serve the how to rent guide, and that's something that we've had a lot of queries on the advice line, that, well, if I serve it now, do I have to serve it on renewal, for example? The answer is you don't have to serve it on renewal unless it's been updated. Now, how are you going to know whether it's been updated? If you're an ARLA member, we will notify you, and I'm sure if you're a member of the other professional bodies, they will notify you. But I'm actually suggesting that best practice at the moment is to serve it in any event, just to make sure on renewal.
Have it part of your system.
Absolutely.
Because it's not going to cost anything particularly.
No.
It's an electronic document that's available online free of charge.
Absolutely. You can get it on the ARLA website, you can get it on the gov.uk website. So it's probably just belt and braces approach would be to serve it on renewal, serve it on periodic, serve it on a new tenancy.
I'd agree with that. And get proof of these things as well.
Absolutely, yes, because you are going to need to demonstrate that you have actually served it. So either a receipt or serve it by email. But if you do serve it by email, remember you have to serve the PDF document. You can't just serve a link to the website.
And you need to get the consent of the tenant
you
as
do
well.
need to get consent of the tenant as well if you're going to serve things electronically. And of course we have a new Section 21 form, which got an awful lot of interest recently, I think is the best way of putting it, in the trade press. Because unfortunately when they published the first version of the form, it wasn't entirely legally accurate, shall we say.
Slight inaccuracies have crept in.
One or two. But we've been working very closely with DCLG over the last sort of month and a half. The form is now legally accurate. An amendment regulation was laid just before the 1st of October, and the new form was published. It is an editable PDF that can again be downloaded from .gov.uk and also from the ARLA website. You need to fill that in, and you must use that form for all new tenancies from the 1st of October, and that includes all renewals as well. But you can use it for all.
My take on it is perhaps if it's not relevant, it's perhaps best not to use it, because it has a lot of things in there which aren't relevant.
This is
true.
And
it may confuse the tenants.
It may, because there is a checklist effectively attached to the form that says, have you served the how to rent guide? Now, you will have to do that, and you'll have to have used it if the tenancy started on or after the 1st of October 2015.
But not previously.
So that does cause problems. But I think going forward, it is actually a very sensible approach. because how many times do you hear and do I hear cases have been thrown out because I put the wrong day on it, and particularly with the changes to Spencer versus Taylor and the 2 clear month versus the end of a rental period, those issues have been now cleared up and clarified in, one, the changes to Section 21, but also in the form itself.
I think a lot of people have been asking for a prescribed form for quite a long time. I mean, I think it should have been done.
It should have been done years ago, but we've now got the government has acted. They have produced something, and I'm actually very pleased.
Yes.
I think it will work well. It will give certainty, and it's that legal and regulatory certainty that landlords and agents crave.
Yeah. New legal changes. What have we got coming towards us, David?
I must say, this has actually probably been the busiest 6 months I think I've ever had.
Yes.
Because we've had, whenever you have a new government, a general election, that first summer is always a nightmare for lobbyists, people that are working in the policy world, because just before summer recess, the new Prime Minister outlines his or her legislative agenda in the Queen's speech. They then spend the summer, whilst all the politicians are off on holiday, the civil servants spent the summer getting everything sorted, working with the key external stakeholders and the various industries. So we've had all the consultations, all the proposals coming out of the Department for Communities and Local Government over the summer in advance of the housing bill that is going to be launched in the next couple of weeks, while simultaneously dealing with all the hangovers of the previous government that came into force last Thursday. So it has been exceptionally busy.
Yes, it has.
But what do we have coming forward?
Housing bill.
A housing bill. We do have a housing bill, which the keynote part of the housing bill was supposed to be the right to buy for housing associations, but at this point in time it's not entirely clear whether that's going to be in it.
Yes.
But we do know that there is going to be a raft of enforcement changes in relation to the private rented sector. So, for example, they are looking at potentially minimum fines for breaching the housing health and safety rating system and landlord licensing. They're looking at, in any event, increasing the level of fines for breaches of Housing Act offences. They're looking at banning orders for landlords and agents, blacklisting landlords and agents. They're looking at fixed penalty notices akin to parking tickets.
Rent repayment orders.
Rent repayment orders as well, and extending them into markets. And actually up to and including freezing and seizing assets. And bringing more properties into management for persistent and significant breaches. On the positive, and actually to a large extent we think that's quite positive anyway, because there is such low levels of enforcement at the moment, and then such low levels of fines that for a lot of these criminal landlords and agents, the risk of getting a fine is factored into the cost of doing business. Now, if we want to improve the sector, we want to improve conditions in the sector, we want to improve management in the sector, and really we want to drive out those tiny minority that bring the sector into disrepute. The only way we're going to do it is by making the financial penalty an actual deterrent to acting criminally.
It's also a huge disincentive for the local authority officers. They have to spend a huge amount of time bringing the prosecution, and if they get a very small fine, I mean, it just makes a mockery of the whole system for them.
Absolutely, I couldn't agree more with you on that one. And one thing we've been pushing quite hard for a number of years actually, and not just ARLA but all the trade bodies, all the professional bodies, have all been arguing that local authorities should be able to keep the fines that are imposed, and those fines should be ring-fenced for greater enforcement activity. And we are hoping that in the housing bill, particularly the fixed penalty fines, but all fines will be able to be kept by the enforcing body, be it environmental health, be it trading standards, and that will be ring-fenced for further enforcement activity. Because what we would like to see is enforcing departments in local authorities, instead of being the revenue drains on the local authorities that they are at the moment, actually becoming revenue generators. And if we can get more fines, means more money coming into the local authority coffers, which means more environmental health officers, more trading standards officers to go out and do more prosecution, and hopefully that will start creating the level playing field that everybody wants.
Drive out the bad landlords.
Absolutely.
Perhaps Perhaps we should very briefly touch on the changes coming into Wales, because there were huge changes there. David was a speaker at our Welsh conference in May, and have we had much development since then?
Well, I must say no, not really, is the honest answer to that question. Since May, we have had a consultation on the Code of Practice, and it was very close to your conference that I was actually down in Wales giving evidence before the Welsh Assembly on the contents of the Code of Practice. But to date, that still hasn't been published.
Okay.
Recently, we've had the syllabus published for what landlords and agents will need to be trained on. There is a course available for landlords at the moment. There's nothing available for agents. But we don't know what the other requirements for agents are going to be. We don't know when the scheme is going to come into force. We don't know how much it's going to cost to become licensed. We don't really know what you're going to need to do in terms of continued professional development, whether you need to be a member of an ombudsman scheme, whether you require client money protection. All of these incredibly important questions are completely unanswered at this point in time, and something that has concerned me really since your conference actually is that they are talking about this is going to be an online system, it will all be done online. They are going to need an army of staff in order to administer this scheme, and I think the Welsh Government has completely underestimated the massive administrative burden that this is going to put on it, and I'm very worried that unless they grasp the administration aspects and the administration requirements of what they are proposing, the scheme's going to fall over. And when the housing bill was first introduced into the Welsh Assembly in 2013, we heralded it as appropriate regulation of the lettings industry.
Yes, definitely.
And something that we have found exceptionally disappointing is from very strong political commitment back in 2013, it has been progressively watered down and watered down and watered down to really now it's not much more than a nationwide selective licensing scheme, which we're actually very disappointed about.
I remember you talked about this in the talk that you gave to our conference, and that is available online, so I will put a link to that on the page where this interview appears so people can listen to that, because that's still very relevant.
It's still exceptionally relevant.
Yes.
And the questions that we were asking then are still the questions that we're asking now, 6 months later.
Okay, so to wrap up, David, what do you think agents need to do to deal with all of this? I mean, training, obviously, putting their systems in order.
There's, I suppose, a couple of things that agents need to do. One, there is constant legislative change in the private rented sector. Whether they are a member of ARLA or one of the other professional bodies, or member of nobody at all, they need to keep up to date.
Yes.
Otherwise, as more and more enforcement is going to take place, they are going to fall foul of the law, and they're going to get hit with some pretty heavy penalties. So make sure you're up to date all the time. Make sure you've got adequate training, not just for the principals, the partners and the directors, but make sure that it filters all the way down to the junior negotiators, the apprentices in the branches. But also make sure that your systems are in place so that you can flag things, and make sure that you've got adequate IT and content management systems, contact management systems in the businesses, so that particularly something like the Immigration Act, which we haven't talked about today, but if the Immigration Act comes into force, and I'm saying if, because it should have been enforced by now, but we just don't know. And you've got a tenant that is on a limited visa, the agent will be liable if they don't check on the day that visa expires that they still have the right to rent. And if they don't have the right to rent, they have to notify the Home Office.
So that needs to be flagged up. There needs to be a diary system. And
there needs to be a diary system. There needs to be a content management system to remind people. Because if you've got hundreds of properties under management, you're not going to remember off the top of your head.
You're not.
I need to check 5 Acacia Avenue on the 14th of August 2016. You're just not going to remember. So make sure you've got those systems in place. And the Immigration Act will come into force at some point. When? I'm not sure. I was actually expecting the Home Secretary to announce it in her speech to Conservative Party conference just a couple of days ago, but she didn't, and therefore we really have no idea when an announcement is actually going to be made as to what will happen outside the West Midlands pilot area.
Well, let's hope in a way that it takes a while, because then that'll give agents an opportunity to get on top of all the other things that they've got to do.
Yes.
Okay, well, look, thank you so much, David, for taking the time to talk to me. You can find more information about ARLA on their website, which is www.arla.co.uk.
Thank you, David.
Thank you very much.